All right. Hi, everyone. My name is Alyssa Chow. Thanks for joining me today for my third installment of Wills and Living Trusts. Just a little bit about me. So I'm an attorney here in the Sacramento area. I was also born and raised in Sacramento. I kind of joke that with the exception of going away to college, that I've pretty much stayed within a 5-mile radius for most of my lifetime. And so I do practice in the Sacramento area. The type of work that I do is in the area of trusts and estates. So I do estate planning, probate, conservatorships, and guardianships, pretty much anything in the probate court realm. My involvement with ACC goes pretty far back. So growing up in this area, when I was in high school, I was volunteering with ACC. And when I came back after college, a few of you, if you're frequent attendees of the ACC Crab Feed, have probably seen me serving or bussing tables. And I'm also a board member of the Sacramento Asian Sports Foundation. Since this is my third installment, my mom is very much aware of the fact that I've been doing these presentations. And so if you ever happen to see Sue Chow out on the pickleball courts for ACC, go ahead and give her a hello for me. So Mom, there's your plug. So today, what we'll be doing is just talking about wills and living trusts. So we'll be going through some information, some of the pitfalls that I've run into throughout my career. I've been practicing now for about 6 years. And so I've seen quite a bit in the way of what makes a good estate plan, what are some documents that everyone should be aware of, and some of the common misconceptions that I run into in my practice when I meet with clients and prospective clients. Okay, so the first thing I want to talk about is what is estate planning. So a lot of people have probably been doing some form of estate planning already, and they may not even know that they've been doing it. One option for types of estate planning is beneficiary designations. So some examples of that would be with retirement accounts, life insurance policies, death benefits, or even a lot of people may not realize, but you can also do that on your bank accounts and investment accounts as well. So beneficiary designations are a type of estate planning because typically what happens is upon your passing, whoever you have specifically designated as your beneficiary is supposed to receive those assets. Another type of estate planning is taking title to property. That's usually going to take the form of either joint ownership on bank accounts or investment accounts, or even real estate. And so sometimes that would be with other individuals, so maybe people that are family members or maybe even a spouse, taking title to property. And the way that you take title to property is really going to affect what happens to that property upon your passing. So for example, with real estate, you've probably heard of the term joint tenancy, and it's essentially a type of titling where it's survival of the fittest, where whoever is the final owner on a joint tenancy property is going to be the owner. However, there are some pitfalls to taking title that way, and so we'll talk about that in a little bit. And the most robust type of estate planning, I would argue, a little bit self-serving since I'm an estate planning attorney, but that would be through the form of legal documents. And so today we'll be talking a little bit more about revocable living trusts and what they are and how they work, last will and testaments, durable power of attorney for finances, and then advanced healthcare directives. Okay, so first let's cover what a revocable living trust is. Really, when we're talking about a revocable living trust, it's a legal contract that provides instructions for control, management, and then ultimate distribution of your assets. And really what it does is it just serves as a legal key to whoever you leave in charge, which is who we call the trustee, and it will provide them with access to assets that are properly what we call funded into the living trust, which we'll talk about in a little bit. But as far as the way that a revocable living trust works, just in the title, it is revocable, meaning that you as the creator, the settlor, or the trustor of the trust, you have the ability to revoke or amend that type of document throughout your lifetime because things change over time. So you should have the flexibility and control to be able to make changes to the documents to suit changing family situations or asset information that you may become aware of later, or inheritances and things like that. So very flexible. And it's also a living document in the sense that the moment that you sign the living trust, it's almost like the birth date, is what I like to refer to it as. So the moment that you execute the trust is going to be when it starts to become effective for you. And so it'll work for you during your lifetime and even after your passing, again, as it relates to control, management, and distribution of your assets. Now, as far as the way that a trust will function, really what we're looking for is proper trust funding. So you may put together all these really beautiful instructions about who your trustees are and who your ultimate beneficiaries are upon your passing, but really the trust is not going to control assets unless they are properly funded into the trust. So only the following types of assets are typically going to be considered properly funded, and that's going to be assets that are titled in the name of the trust. So for example, if we're talking about real estate, we want to make sure that that real estate is titled in the name of your trust. You don't want that property to be left just in your name individually, because eventually, let's say I have a house and it's left just in my name and I were to pass away. Well, if my husband wanted to sell that property, he would try to do that, but he wouldn't get very far. A title company would look at the way that the title of the property is held, and if it just says my name on there, then the title company is going to be looking for me to be the one to sign those documents to sell. So he would not have the immediate ability to do anything. And if any, what usually ends up happening in my practice is somebody will get all the way to the close of escrow, and title will point out that the named person on the deed is no longer present or incapable of executing the sale or the transfer deed. And so one way that we make sure to get around that is if you have a living trust, you want to make sure that that property is titled in the name of the trust so that, again, if something happens to me, but my property is in the name of my trust, then my husband, who I would have as my co-trustee, would be able to essentially work directly with the title company to ensure that the property can be sold, because in the trust, we will have given him authority to manage, control, sell, do whatever he needs to do with real estate. Same thing with bank accounts or brokerage accounts. Those types of accounts, we'd also want to make sure that they're actually titled in the name of the trust. So it's not enough where you may have a list of assets that are maybe connected to the trust as an attachment where you have property listed. You really need to make sure that you take that extra step after you create and execute your trust to make sure that those types of accounts or assets are properly actually titled in the name of the trust. And then another type of way that you would connect or fund assets into the trust would be by designating the trust as the pay on death or transfer on death beneficiary of those types of accounts. So, for example, retirement accounts and life insurance policies, in some situations, and depending on the goals that my clients have for their ultimate beneficiaries, we may want to funnel the funds from those retirement accounts or life insurance policies through the trust upon their passing so that the trust can actually control what happens to the ultimate distribution of those funds instead of naming direct individual beneficiaries. Some examples of reasons why we may do that, it would be because you have a minor beneficiary, which in California, minors cannot receive funds outright. So let's say I named a minor child as the beneficiary of my life insurance and I were to pass away while they were a minor, that money can't actually go to them directly without somebody petitioning the court to be their named guardian and then manage that money for them until they're 18. So one reason then to get around that would be to do a revocable living trust, and we'd name the trust as the beneficiary instead. And in that trust, we would have very specific instructions for the management of those assets for the minor beneficiary until they turn at least 18 or whatever age my client would want their child to receive that money at. So one thing to note is that, like we've talked about before, any assets that list specific or direct beneficiaries and not the living trust will essentially just pass directly to those beneficiaries, and they would not be controlled by the terms of the trust, which, depending on the situation, may be appropriate. Okay, so another document that is going to be very helpful with an estate plan is your last will and testament. So this is probably the document that most people are familiar with when it comes to estate planning. And I think Hollywood has really popularized a last will and testament as the main estate planning document. So what most people are familiar with is the standalone last will and testament, so something that's completely separate from a trust and where somebody has not created a trust. This would basically allow you to state where you want your assets to go upon your death and who should be in charge. So very similar in function to what a revocable living trust allows you to do. However, this document only becomes effective upon your passing and will eventually ensure that your assets are going to who you'd like them to go to, but it just is a different administrative function, and there's a different process for how that happens. The other type of will that's going to be specific to the realm of a revocable living trust is what we call a pour-over last will and testament. So this is really just going to be a backup document that I always create with my estate plans when someone is creating a revocable living trust. And what it does is it just makes sure that any assets that were not properly funded into the living trust or that don't have a beneficiary designated, they basically would just get scooped up and poured over into the living trust. And depending on the value of the asset that got left out of the trust, you may or may not need to deal with the probate court. So my goal with that is that the pour over will never has to be used, but it is a good backup so that anything can get redirected back into the trust that wasn't otherwise funded. One of the most common misconceptions I think that I hear most often from clients is that having a last will and testament is really the only document that you do need, or that it would avoid probate. And that's not necessarily the case. With a last will and testament, let's say that's the only document that you have as your estate plan, really what ends up happening is that the probate court is the only entity with the authority to oversee the administration of a last will and testament. And it also is not going to be very helpful for you during your lifetime because it only becomes effective upon your passing. Okay, so what is the probate court? I know that a lot of people know that they probably want to avoid the probate court, but they're not quite sure exactly what it is or what it does for people. And so really what the probate court is it's just for individuals who either have insufficient or no estate planning documents at all. So the probate court itself, like I mentioned, would oversee the administration of an estate. And that would be for individuals, let's say you're still alive but become incapacitated. A very common example would be you suffer a stroke, or as we age, we might start to develop cognitive deficits, or something like Alzheimer's or dementia, and we're unable to manage our own finances anymore. If we don't have the appropriate estate planning documents in place, like a living trust or powers of attorney, which we'll talk about in a little bit, then the probate court is really the only entity that has the authority to appoint somebody to manage your affairs. And that's, again, either during your lifetime if you become incapacitated, or if you were to pass away and you did not have the proper estate planning documents. The other thing about the probate court is that it's a pretty lengthy process to deal with. So I pretty much practice in most Northern California county probate courts. But if we're looking at Sacramento County in particular, since that's where I'm assuming most people who are tuning in where you reside. But Sacramento County in particular is pretty backed up at the moment due to COVID and court closures and sort of minimal services that are available at this time. If you wanted to get something done in the probate court in Sacramento County, you'd have to wait somewhere between 5 to 6 months just to get a first hearing date for someone to either be appointed or for you to get an answer from the court about something that needs to be done. So that can take quite a long time, and that's just to open up a probate process, whether it's a conservatorship or a full probate administration because someone's passed away. You're looking at probably a minimum of about a year to even 2 years to really get things settled. So it is quite a lengthy process, and along with a lengthy process, that means that it can also be pretty expensive. I tell a lot of people as an estimate, let's say you pass away and you leave behind a house, right, your primary residence, and we estimate that it's worth $300,000 at the time that you pass away. Based on the way that California calculates attorney's fees and executor's fees, you're looking at a minimum of $9,000 just to transfer a piece of real estate to your heirs. And that's just the attorneys and executors' fees. That doesn't include the third-party fees that go to the court or to the legal publication that you have to publish notice in, and all the other little miscellaneous fees that come along with any sort of court proceeding. So it can be pretty expensive to deal with the probate court. So we want to try to avoid that as much as possible. And then finally, when you're dealing with the probate court, it is a public forum. So theoretically, anybody can log in. Right now, Sacramento County is doing all Zoom hearings. So anybody can log in and watch the hearing that is occurring regarding your estate. And a lot of the documents that are associated with a probate administration are also going to be public record. So if somebody wants to, they can put in a request with the court to get copies of all of the documentation that's been filed in your case, which would include all the names of your heirs, their contact information, and then also, to a certain degree, information about the assets that are part of your estate. So as much as possible, everything that we're talking about today as far as the legal documents, it's all really meant to try to avoid dealing with the probate court for administration during your lifetime or after you've passed away. So inevitably, the next question that I'll get from clients is, all right, so what's the difference between a will and a trust, right? So we've kind of talked about how each of them work, but what's the main difference? So with a will, it's likely going to require probate because, like we've talked about, the probate court is the only entity with the authority to oversee the administration of a will. It's also a public forum, so anybody can gain access or get copies of documents, and it's effective only upon your passing. So a will is not going to be effective for you during your lifetime. Whereas with a trust, it does not automatically require probate, and it also is something that can be privately administered. So if you have a trust and it's a legal contract, similar to many other types of legal contracts, nobody else really has authority to see the documents unless they're somebody with an interest in the documents. So that would be yourself during your lifetime, right? So while you're alive, you control that. And after your passing, it would be whoever your beneficiaries are. So they are really the only individuals who have the ability to see all the trust information. Naturally, you'll have to give information to the banks when you're funding or retitling your assets into the name of your trust. But even then, there's what we call a certification of trust, which is like a nice little handy summary of all the main provisions that a bank or any sort of asset institution would need in order to fund your assets into the trust. And most importantly, it's going to be effective during your lifetime and after your passing. So we've talked a little bit about what it looks like when you become incapacitated. And so all the assets that are properly funded into the living trust can still be managed during your lifetime by your successor trustee or whoever it is that you put in charge, right? You've entrusted with that authority. And upon your passing, everything that's funded into the trust, again, is going to be controlled by the trustee, and then they will eventually handle the distribution of those assets. Okay. So I do have one question that's come in, and it says, what exactly is an irrevocable trust, and what are the advantages of it versus a revocable trust? And that's a really good question. So, Usually when it comes to an irrevocable trust, that's going to be a very specific type of trust, and there's lots of different ways that an irrevocable trust can be created and a lot of different purposes. But a couple of common examples are going to be, if somebody anticipates that they're going to need Medi-Cal in the future, then they may want to create what's called an irrevocable trust and start funneling their assets into that irrevocable trust. And it takes those assets out of their control, and somebody else, a third-party trustee, would be managing that money for them or whatever those assets are for them. And it, for all intents and purposes, essentially looks like they don't own those assets anymore. And later on, if they need to be qualified for Medi-Cal, when you are submitting your application for qualification, it looks like your assets are significantly reduced because they've been pushed off or sheltered into a separate irrevocable trust. So the benefit of that would be, if you're pretty sure that you're going to need Medi-Cal in the future, you may want to consider pre-planning with an irrevocable trust, but you just need to know that once that irrevocable trust is created, you are no longer controlling the assets that are put into that irrevocable trust, and it also cannot be changed typically, except if you need to make a change, it would have to be done by court order. So it's a little bit limiting there. And then another common example of a reason why someone might do an irrevocable trust is if they need to minimize their estate for estate tax purposes. And so right now, that's not so much of an issue for a lot of people. The estate tax exemption amount is pretty high. It's about I think between $11.7 and $11.8 million per person for 2021, meaning that if you own assets above that value, you'll be taxed at a very high rate. So some people like to try to shelter their assets or minimize their assets for estate tax purposes. There is some discussion about that estate tax exemption amount being lowered sometime in the next year or a couple of years, depending on what happens with the Biden administration and the estate tax exemption amount. But that would essentially be some main reasons why someone might do an irrevocable trust. And so it would be for a very specific benefit. And the trade-off to that would be it's an irrevocable or unchangeable trust when it comes to the terms. And you also have no control over the assets that you put into that irrevocable trust. Okay. So moving on to a few other documents that are going to be really key for an estate plan, legal documents at least, that would be your durable power of attorney for finances. So probably for a lot of people who are tuning in, you're probably familiar with this type of document, but really what it does is it allows you to appoint an agent or some individual that you trust to act on your behalf regarding finances during your lifetime, and that's even if you become incapacitated in the future. So we've talked a lot about how the trust can manage assets that are properly funded into it, like your house or bank accounts or investment accounts. But we've also got other accounts like your retirement or your life insurance that are going to have to stay in your name individually during your lifetime. So if you become incapacitated in the future and you need to deal with the plan administrator for things like your required minimum distributions or any tax filings or other elections that need to be made related to finances that are in your name individually during your lifetime, it's really helpful to be able to appoint an agent under your durable power of attorney because if you do become incapacitated, then that agent can present the copy of the power of attorney to the plan administrator or to your tax advisor to assist you with any of those items moving forward. If you did not have a durable power of attorney and you became incapacitated, really the only way for someone to be able to assist you with any of those items that would not otherwise be controlled by your trust would be if they went to the court and asked for what's called a conservatorship. And I think the hottest topic right now that most people are familiar with when it comes to conservatorships would be Britney Spears, for example. So somebody who even, like a celebrity who didn't have proper estate planning documents, if they become incapacitated even temporarily, they do need somebody to be appointed formally by the court, and that can be quite expensive and can last for quite a long time. We've talked a lot about, what it looks like to deal with the probate court. So that would be the durable power of attorney for finances. The other really helpful document, which is also a power of attorney, but in California we call it an advanced healthcare directive, is going to be a document that lets you appoint an agent who would be your trusted individual to make any medical decisions for you during your lifetime if you can't make those medical decisions for yourself. I would argue that this document is going to be the most important, and the most important factor of the document is who you appoint. It's really important that that individual knows what your preferences would be, because the medical situations that can come up throughout your lifetime are going to vary and can be very specific. So even though you may be able to, in that advanced healthcare directive, specify what your preferences are regarding care or types of treatment to be administered or withheld during your lifetime, the most important person in that document, other than you, of course, would be who you've appointed as your agent, because at the end of the day, your healthcare provider is going to listen to your agent for what your treatment options are going to be, what's going to be administered or not administered. A big question that I get from a lot of clients is, well, what's the difference between this and a POLST form, which is the Physician's Orders for Life-Sustaining Treatment form? You'll probably be familiar with this. It's the bright pink sort of cardboard thick form that you might see people put on their refrigerators or keep in their files. That's going to be a separate form from an advanced healthcare directive, and that's more so a physician's order that you work with your doctor to create, and that's regarding whether emergency personnel can just touch your body to provide care if you're in an emergency situation, or regarding life-sustaining treatment like artificial nutrition or hydration. One question that came up from one of the people who's tuning in is, if they're not married, have no children, and don't necessarily have somebody who they can rely on, like another sibling, who can help make any medical or financial decisions for them, how do they identify and designate an appropriate agent? And that's a really good question, and actually the topic of my next presentation that's coming up next month. But there are what we call professional fiduciaries that are out there and who are available, and these individuals are licensed by by California. They're also bonded, so they have insurance. And these individuals you can hire to be named in the documents. And essentially what they do is, if you become incapacitated, these licensed individuals will be able to step in and assist you with anything financial or medical in nature, if that's what you desire. And they will eventually, once they do step in to assist you, that's at the point that they start to actually charge for their time. Otherwise, just naming them is not going to be a charge to you. But it is good because they are a neutral third person who will do this for a living, and so they're very familiar with what their requirements are legally and what duties they owe to you and what all the kind of necessary steps are going to be for taking care of you, either financially or medically. Okay, so what are some of the benefits of doing estate planning? Really, it's going to be, like I said, avoiding probate court, right? That's going to be the most important piece. And really, once you put together all of the very specific instructions of everything that you want, then that's going to really create an ease of administration of your affairs according to all of your wishes. So I would say that you get to control all of the terms of how things are going to be managed, and you can also ensure that everything will be managed privately and hopefully very efficiently, depending on who it is that you put in place. If they're familiar with administrations or if they're a very organized person, then they can basically carry out your wishes in an efficient manner. All right. And then finally, who is estate planning appropriate for? So at a very minimum, I always say that every adult should have at least a durable power of attorney for finances and an advanced healthcare directive. And so that's really going to be, as long as you're 18 and up, those documents are going to be very important. And then finally, a living trust specifically is going to be important for if you have minor beneficiaries, because like we mentioned at the beginning of the presentation, minors cannot receive funds outright in California. So a living trust is really important as a vehicle for ensuring that any minor beneficiaries are taken care of during their lifetimes, or at least until whatever age you feel appropriate for them to receive the funds. And then it's also going to be really good for beneficiaries who are not good at managing money, or possibly even beneficiaries who are on public benefits. One type of estate planning that I kind of practice in is special needs trust planning. And so if you have a beneficiary who is on public benefits, you don't necessarily want them to inherit a large sum of money or assets that could potentially disqualify them from receiving public benefits in the future. And so it's really important that we put the appropriate language in place that will ensure that they can still keep their public benefits going. And then finally, as far as the estates that are going to be worth over $166,250 in value and or any sort of real property or real estate, that's going to be a threshold kind of trigger for deciding whether or not an estate plan with a living trust is going to be appropriate for you. All right, and that concludes my presentation for today. If we have any questions that are coming in, I'm happy to answer any questions. Otherwise, I am offering a free consultation to anybody who wants more information about all the different documents that we've talked about, or if you do have your own estate planning documents in place and you maybe want a review of those documents, I'm happy to provide that service as well. Okay. So do we have any questions that are coming in? So give a little bit of time. Oh, okay, so the next question is, how do you contact me for an appointment? So I do have my contact information up on the screen. My phone number is 916-619-6163, or you can send me an email. I'm happy to respond either way. And in case anybody is interested in a little bit more information about fiduciaries and what they do and what types of services that they provide, I am going to be doing a presentation on November 18th with ACC again, and that'll be on Thursday the 18th of November at 5 p.m. And I will have an actual California licensed professional fiduciary by the name of Shannon Downs. She'll be present with me during that presentation so that she can also answer some questions about common situations where she may come in as a professional fiduciary to act as someone's agent under their power of attorney, either for finances or healthcare, or even acting as a trustee of a living trust. Okay. All right, well, thank you everybody for tuning in today for my third installment of Wills and Living Trusts 101. If you have any questions, again, feel free to reach out. Otherwise, stay tuned for any future ACC presentations. Thank you.